Good morning. Happy Saturday. A topic that's near and dear to me is the law. And I have been asked a question that I thought was a relatively good question, albeit very open-endedly phrased. And that question was, how would you, meaning me, how would I defend the Marquette County Sheriff if I was in Samuel Hall's position? And that is a very tough question. Let me just preface everything I say here with all of this is contingent on what the actual facts are on what I've only listened once passively to Leonard French's reading of the complaint, and complaints are subject to being amended. First amended complaint, second amended complaint, etc., etc. So all of this is just really super superficial. I have done no research on any of this stuff in preparation, and this is just me spitballing based off the facts that I'm aware of. How I would generally go about the legal defense, not advocating in public for the officer or the sheriff. I have no idea what the sheriff's goals were or anything like that, or what the motivation behind the public speaking was. Again, I don't have any problem with what the attorney said, and there is no ethical problem as defined by the model rules for professional conduct, but I don't know what his goal was. So anyway, my basic legal defense. First thing I do, obviously, is I would get all the facts that I could get, because that would change everything, and the facts might, like Samuel Hall suggested, not actually agree with the complaint. The second thing I would do is I would find an expert or experts who can go over the medicals for the daughter, Cohoon, to see if what she is claiming and what her doctors are claiming is in fact accurate, etc. Not that I'm so sure that that's going to be the best angle of attack on it, because all she had to do was reasonably believe. Even then, I don't even know how much that's going to come into play with it. But I would want to know if what she was saying is true. That might have some bearing on it. There were allegations, or if I remember correctly, there were some allegations about defamation in there, that some of the statements made were defamatory. So if they were, the truth is a great defense. As far as the damages are concerned, obviously I would assert qualified immunity on behalf of the officers, or have the officers assert qualified immunity, the sheriff and the sergeant. I don't know if Samuel Hall is representing both. If he's not representing both, then I would just have him asserted on behalf of the sheriff. As far as the nominal damages are concerned, I think qualified immunity would protect the sheriff from the nominal damages, or at least there's a good shot of it, because this is such a novel situation that I don't think there's any case law on it at this point saying what kind of rights the government has as far as speech are concerned in a pandemic to prevent public panic. And yes, I would frame it as public panic, because that would be my job. I mean, if in fact the facts suggest that the sheriff did order the girl to be silenced, then yeah, I would have to make the argument that it is a public panic. Now, as far as the injunctive and declaratory relief is concerned, actually, as far as the whole case is concerned, I guess mostly, considering the courts are probably closed right now, and the case probably won't be heard until after the pandemic warning is lifted, I would argue for the mootness doctrine. The situation has passed. There's no standing anymore. There's no one really to gain from any of this. She's not going to post any more pandemic pictures, and if she does, it's not going to incite any public panic, because the pandemic has passed. So I'd go for a mootness doctrine approach, and then I would if anybody remembers the strict scrutiny analysis, the government can restrict speech as long as there is a compelling enough government interest, and it is the narrowly tailored, it's the least restrictive means of achieving that compelling government interest, and it's viewpoint neutral. I don't think viewpoint is an issue on this particular post. She said she had coronavirus, I think is what she said. I don't remember exactly. But anyway, I would try to craft an argument, probably, again, depending on the facts, try to craft an argument that there was a compelling enough government interest to prevent the panic, and that the approach was narrowly tailored and it was the least restrictive means of doing it. I mean, they didn't require that she delete the information from her computer. They required she take it down from the internet. Is that the least restrictive? I don't know, but I'd make an argument that it was. So that's how I would defend him. Now, I just want to remind all the pea-brains out there that these are not my views. I think that what the sheriff did and what the sergeant did was pretty despicable and was a clear violation of the First Amendment. But if I was the lead attorney in charge of defending the sheriff in Marquette County, then I would have an obligation. I would have an ethical duty under the rules of professional conduct. I'm assuming that whatever state they're in shares similar rules. I would have a duty to zealously advocate for my client. And that would be to put forward every defense that I could in good faith put forward, and make every argument in good faith that I could make. So this is just a hypothetical. Hope you enjoyed it. Hope it gave you something to think about. Thanks for watching. Have a great Saturday.